Welcome back to CEO Money. I'm Michael Yorba, your host.
And I'm Irving Price, co-host.
All right, we've got Laura Anthony, founding partner, Legal and Compliance, LLC, legalandcompliance.com. All right, now, attorney Laura Anthony is the founding partner of Legal and Compliance, a national corporate securities and business transaction law firm. For the last 24 years, Ms. Anthony has focused her practice on small, mid-cap, private and public companies, the OTC markets, NASDAQ, New York Stock Exchange, American, going public transactions, mergers and acquisitions, private placements, and other corporate finance transactions, Reg A+, Exchange Act, and other regulatory reporting requirements from FINRA to DTC requirements, general corporate and transactional law. Ms. Anthony and the team at Legal and Compliance have represented issuers, investors, shareholders, underwriters, private placement agents, and in going public transactions, mergers and acquisitions, and corporate finance. It just goes on and on and on. Bottom line is, this person, this entity here and her business, they handle it all. Laura, welcome to the show.
Thank you, Michael. Thank you for having me, and you did really well with that big mouthful.
Yeah, I was beginning to wonder myself.
When we're going to get to the interview.
Yeah, I was going to beg Laura to jump in on you there, Michael.
All right. Well, you and I are going to be fast friends. We had a horrible time reaching each other, one busy person and another busy person. But I had a great conversation with our introductory person, Glenn Bierman, that put us together. And we're going to be hearing a lot more from you on this show. But please, Laura, you're welcome. Did I miss anything in the background, the bio, your company that you want to bring out?
I think you've got it all. I've been practicing since 1993, always in corporate and securities, and we have a really great firm here. We've established a big footprint in the small cap and space, and enjoy the work.
You mentioned Glenn Bierman, so I would assume then there's a lot of Reg A legal work you do with him?
Yes, we do a lot of Reg A's together. I met Glenn a few years ago, and he's a great client and a great referral source, and I really enjoy working with him, and I love the Reg A space.
All right, let's talk about it then.
Sure.
Tremendous opportunity for small companies under $50 million. Walk that out for us so you can tell us some insights that you have that maybe other people wouldn't even know to think about.
From my perspective, I'm a huge advocate of Reg A+. From my perspective, if a company wants to do a going public transaction and they're raising less than $50 million, there's no reason to use any other process than Reg A+. Look, it's just a process. It is really a going public process. It is a going public transaction or a public offering in any event. And if a company is doing a public offering, this is the best process for them. The money doesn't fall from the sky, but it gives them some great tools to use to be able to access capital. So what are the differences between a Reg A+ and a regular IPO? I'm sure that's what everybody is wondering. And there's several main differences. But one of the big differences is that Tier 2 of Reg A+ preempts state blue sky law. And what that means is every state, in addition to the federal government, every state has its own securities statutes, its own securities regulators, and its own securities process. And unless the federal government specifically says, we're in control, Mr. State, you can't control this, be a part of this process, then a person has to comply with both, or an entity has to comply with both state and federal law. So there are certain offerings and certain types of securities offerings and types of different aspects in the securities laws that are preempted, and the federal government says, we're controlling this process. The federal government has done that in Tier 2 of Regulation A. They say, we're controlling this process, so the company doing the offering does not have to also comply or register with the states where they're offering. In an old-fashioned IPO, the company has to comply with the state law as well, and that can be very expensive and arduous. It's really a difficult process. A lot of states have what's called merit review, meaning they look at the merits of the company and the merits of the offering itself as opposed to just the disclosures, where the federal government is all about disclosures. You have to really tell it like it is, and then the investor can decide if that's a good risk or not a good risk. Some states want to weigh in on whether or not it actually is a good risk, and if they don't think it is, they're not going to allow an offering to proceed. So on a high level, the first big benefit of Reg A+ is that it preempts state blue sky law. A second huge benefit of Reg A Plus is that it allows for communications with the public about your offering, both before you file, during the review process with the SEC, and after you file. And people have heard terms when they hear about IPOs. They've heard quiet period as a term, and they hear gun jumping as prohibited activities. We're in a quiet period. We can't talk about our offering. No one can even know we're doing an offering in a traditional IPO. In a Reg A Plus, not only can you get up and shout it from the rooftops, but it's encouraged. And the only prohibitions are that you have certain disclaimers and that you don't take anybody's money until you're qualified with the SEC. It's a huge difference in the communication process and what's allowable in an IPO. And a third benefit is that the SEC promised that their review process was going to be less lengthy and a little easier than in a traditional IPO, and they've been true to their word.
Laura, that was amazing. You're obviously extraordinarily passionate about this, and you have an encyclopedic knowledge of the SEC and its changes, but it has changed. What's it like now since Mary Jo White kind of got out of the SEC, and we had Michael and then Jay? So talk to me about the changes you've seen in the SEC.
I see a huge difference. So Mary Jo White, and I'm not putting her down, but she had a real cop mentality. She was a former prosecutor. She had a very cop mentality. She was not pro-business, and she did not like the Jobs Act. She did not like crowdfunding. She delayed a lot of regulatory actions to implement these procedures, even though ultimately she had to. She was pro-Dodd-Frank, and that was not business friendly. Jay Clayton is business friendly. I mean, every speech he's given, and even at the actions by the SEC since he's been in office, are extremely pro-business. Michael Pilar, who's also a commissioner, is also pro-business. The SEC recently came out with their flex regulatory agenda. That's their agenda of rulemaking that they have on their plate. And number one, it's less lengthy than prior years. It was in the number of regulations last year was over 60. This year, it's in the 30s. And one thing that you're not going to see in those 30-some regulations that are on the SEC's plate for this year is anything that's going to further Dodd-Frank. When Dodd-Frank, everybody knows, is not pro-business. But what you do see is regulations that are going to change the disclosure requirements, to make them more business friendly, to adapt with technology to the changing world that we're at. You see changes in definitions that are more encompassing, and it's just very pro-business. And one thing that also Jay Clayton is committed to doing is to getting the IPO market and the U.S. capital markets back on track, because they've really slowed down in the past couple of decades. And U.S. used to be the number one marketplace. It's not anymore, and they're very committed to making it the number one marketplace as well. And at the same time, they're not foregoing their enforcement proceedings. They're not going after fraudsters and making sure that people feel it's a safe marketplace. They're doing both at the same time. It's really refreshing.
Laura, we've only got about a minute left. I wanted to get into what's going on here with the blockchain and ICOs. How's that being
What's an
impacted?
ICO, Michael?
Let Laura explain it.
An ICO is an initial cryptocurrency offering, and Bitcoin and Ethereum are good examples, and it is the new hottest craze. I would love to talk in depth. For in 1 minute I can't, but blockchain technology is really in the broadest sense a database, and it's a way of accessing and building a database that's protected and that a group can access and grow at the same time instead of a single person. It's decentralized. And tokens, cryptocurrencies or tokens, are something that represents an underlying asset or an interest in an underlying asset in the very broadest sense. And they are the new hottest craze. The SEC has taken notice. The SEC came out with a report. It did an investigation into an offering by the DAO, and the SEC in its report said that a cryptocurrency that walks or smells like a security is a security, using old-fashioned Howey test, which is the U.S. Supreme Court case on defining a security, has been for many, many years. And the SEC said if it looks like and walks and acts like a security, you can call it whatever you want. You can call it an orange. It's still a security. and it can be have any kind of technology associated with it. It's still a security. So it's going to be really change. ICOs are changing the type of securities that can be issued, from one thing, and blockchain technology is changing how those securities can be traded and accounted for. And that's through digital ledger technology. And we're going to see our clearing systems, our transfer agents records, our shareholder records. We're going to see vast changes in our markets and in our capital markets and how they're run and how securities are cleared in the coming years. And the only thing slowing it down is regulators getting their heads around it and putting in proper regulations in place to keep up with this amazing technology.
All right, Laura, we've got to close for now, but boy, that was a wonderful segment. I'm glad, and I want you again to come back.
Such energy.
Be happy to come
Thank
back.
you.
You got it.
Thank you. Laura Anthony, founding partner, Legal and Compliance, legalandcompliance.com. We'll be right back on the other side of this break with Steve Cannibal, portfolio manager, Meehan Investments, and our new columnist. You've been listening to CEO Money with Michael Yorba
And Mervyn Price.
We'll be right back.